Hello, Judge Peterson, do you hear us?
Yes, I do. Good morning or good afternoon.
Good afternoon. All the participants of the roundtable now have the earphones, so we are ready to listen to your presentation about pros and cons of the right to bear arms. Thank you very much.
Thank you. Let me introduce myself. I am Chief Judge Ruzanna Pitterson. I am the Chief Judge of a federal court in the Eastern District of Washington in the United States of America. And I have been asked and invited.
Просили, щоб я взяла участь в цій конференції стосовно викликів і переваг, які мають Сполучені Штати, закони Сполучених Штатів стосовно права на носіння зброї. Я думаю, що ви довіряєте мені. Дякую. Друга поправка до Конституції Сполучених Штатів – це джерело, стосується права на носіння зброї, на володіння і носіння вогнепальної зброї. Друга поправка, в основному, в другій поправці сказано, що добре відрегульована Національна гвардія захищає права людей для того, щоб володіти зброєю. І ці права не повинні порушуватися. Є декілька слів стосовно цієї другої поправки, які були сказані в 70-ті роки. І це викликало багато проблем в Сполучених Штатах. В історичному контексті багато людей вважають, що ми взяли цю ідею стосовно права носіння вогнепальної зброї з англійського закону, англійської поправки, де англійський закон про права гарантує, що громадяни можуть володіти вогнепальною зброєю для власної необхідної оборони і можуть бути частиною Національної гвардії або армії, і це право надано національним урядом. Розробники закону з Конституції Сполучених Штатів склали наступну таку програму. Вони сказали, що вони дають це право як частина Конституції, право, яке було зрозуміло англійськими нащадками, які відкрили Сполучені Штати. І суд Сполучених Штатів нещодавно оцінив цю поправку. Як такий закон, який інтерпретує другу поправку. Це була створена і розроблена і ратифікована рішенням Верховного суду. В нашому випадку округ Колумбія має такі обмеження, і Верховний суд сказав, що це друга поправка.
The United States Supreme Court defined the Second Amendment as an inherent right of self-defense. It, however, is not an unlimited right for any person to carry any type of firearm. So even from the early part of our country, the right to bear arms had to be the type of arms or the type of firearms that people commonly had for law-abiding purposes. So there are prohibitions in the United States on the right to have firearms. These prohibitions have been in place for 100 years or more. It includes the type of people who can have firearms. People who have committed serious crimes known as felons, are prohibited from having firearms. And people who have committed domestic violence crimes, those are crimes against people in their same family or people with whom they live. Those people are prohibited from having firearms. People who have mental illness are prohibited. And people who are drug addicts are prohibited. All of those types of people may not have firearms at any time. There are also restrictions on the types of places where firearms can be carried. One place is schools. Another place is government buildings. And a third place are places like national parks. There are restrictions on people who can sell firearms, and those places have to be licensed. They have to conduct background checks, and that's if it's a business. However, there are not restrictions of one person selling a firearm to another person. There are types of firearms that are restricted. As I mentioned before, the Second Amendment right to have a firearm was based on the idea of self-defense and also of being called up by your government to be part of a militia. So the Supreme Court and the laws of our country have viewed certain types of firearms as not being consistent with those types of ideas. So certain firearms that are prohibited by law include short-barreled shotguns because no reasonable relationship exists between the efficiency of a well-regulated militia or for hunting purposes and a short-barreled shotgun. It was not the type of firearm that was typically possessed by a law-abiding citizen for lawful purposes. Another prohibition is machine guns for that same reason. There is also a prohibition of various types of ammunition, that type of ammunition that is intended to inflict the worst damage. For instance, hollow point ammunition or armor-piercing ammunition or ammunition that is 50 caliber or greater in size. That does not fit with the idea of citizens for self-defense or citizens being called up as part of a militia. So that is the basic idea of the Second Amendment right to firearms. However, these prohibitions have obviously not resulted in no crimes being committed. As you're aware, unfortunately, in America, we have had shootings at schools. We have had possession of firearms by convicted felons. We have mentally ill people who are able to get firearms. We have firearms that are taken by people who are using drugs or who are drug addicts to use in crimes. So the laws are broken sometimes, as other laws are broken. So there have been firearm-related events, and that has resulted in various additional laws being passed. After school shootings, there were 2 states who passed laws to ban all assault and semi-automatic weapons, and also to ban large capacity magazines, the container that holds the ammunition for a semi-automatic or assault weapon. There have been additional laws passed and additional rules restricting firearms within a certain distance of a school or within a place like a courthouse. And there have been different rules established as to whether a citizen can carry a concealed weapon, a weapon either inside a bag or inside their jacket or other clothing. The case that I mentioned that the Supreme Court decided in 2008 was a case involving a handgun inside of someone's home. And the Supreme Court decided on that was protected. That's one end of the spectrum. And that fits very well, the justices said, with the type of firearm that traditionally is held for self-defense by law-abiding citizens, and protecting one's home is the type of interest that the Second Amendment intended. But there are many other ideas, such as the assault weapons or the concealed weapons, that are perhaps on the other end of the spectrum. And our country has a variety of laws where they try to control what the behavior is of people who misuse firearms. There are many questions that have not been resolved on a national level, even though we have had several hundred years of working on this. Some of the issues include, can a child have a firearm? What if the child is being supervised by a parent? Can a firearm be possessed by a child at that time? And how old of a person does one need to be in order not to be considered a child? 18 years old, 21 years old. The opponents of firearms and the people who are working to restrict firearm possession and to close some of those gaps legally argue that firearms mean there is more violence that occurs, especially more violence in places like schools and public places, because despite the laws, there are obviously people who break the laws by taking guns in and shooting people. The opponents argue that there would not be as many people injured or killed without the use of firearms. And it's been interesting to note that recent violence in Israel and Palestine has had firearms on one side and knives on the other. There is still violence that is occurring there, but what is the quantity, excuse me, of the violence? The other issue that people who oppose or would like to further restrict the right to firearms say is that having a firearm, having a handgun, for instance, makes people react too quickly in a dangerous way, instead of having to slow down and think about their actions. The proponents, or the people who strongly encourage the Amendment rights for firearms, argue that firearms protect people against bad people, against criminals who are going to cause injury or action. So firearms level the playing field. They allow regular citizens to protect against criminals. Also, the people who argue in favor of firearms state that it allows the people to remain a strong part of the potential protection of a country and to be called up again as a militia to protect against invaders or other people who the government wants to prohibit. Some people in America feel strongly that their right to have a firearm also means that they have the right and the duty to protect against the government being overreaching, and that there's always the possibility of individuals being able to form up in a militia and take arms against anybody who is overreaching. And then there are people in America use firearms for sport, either for hunting, to get food by shooting deer or elk or birds, or are using it for sport such as target shooting. And a further use in the sporting arena are individuals who camp in the wilds and protect against wildlife such as bears. We in America have been struggling with a number of legal issues regarding the right to have firearms. The original Second Amendment uses the word militia. What does that mean? What did the drafters of the Second Amendment mean by the word militia in 1789? Did they mean only those people who were called up by the authorized government in order to have a firearm and to fight against enemies? Or is there a term militia that implies that people can act as a group independently of the government? Another issue that has been raised and discussed is whether firearms have become too efficient in 2015 as opposed to the firearms that existed in 1789. It is very different to have a firearm that is semi-automatic and can shoot or fire off multiple rounds of ammunition as opposed to an old musket, old-time musket, where the powder had to be loaded into the firearm. The courts in America and the lawmakers struggle with how much restriction can be placed before the people's right to bear arms is violated. Those are questions that we have been asking ourselves and that we have been challenging. And as you are going forward in your discussions, I would suggest that the use of words that you choose have to be words that can be understood and interpreted for hundreds and hundreds of years. And that is part of our challenge, is trying to understand the words of the Second Amendment. I would be happy to answer questions if there is anything that anyone would like to ask me.
Judge Peterson, thank you very much for your taking the floor. Can we put your question just now? Это не имеет значения. Так, какие вопросы? Питания еще будут? Які запитання будуть у колег? Немає запитань? Oh, no question. Thank you very much.
Thank you very much.